We have two cases remaining on our docket today. The next case is City of Jacksonville Beach versus Brothers 5 of Jacksonville. Counsel for appellant, you ready to proceed?
Yes, Your Honor.
Okay.
May it please the court, my name is Susan Erdely, appearing on behalf of the City of Jacksonville Beach, and I would like to reserve 5 minutes.
So noted.
This case is an appeal from a writ of mandamus from the lower court. The subject matter of the writ of mandamus was a sign frame. It was an abandoned, discontinued sign. A citizen from the City of Jacksonville Beach had made a complaint to the city that this sign frame was in violation of the sign code for the city. Before engaging in code enforcement on this sign, the city officials and the owner's representatives sat down and attempted to resolve the issue with this abandoned sign frame and to come up with a solution that would fit within the city's current sign code. Those attempts were unsuccessful, and it was only after that that the city began and commenced code enforcement. The code enforcement proceedings in the City of Jacksonville Beach are conducted under a special magistrate system. Under Chapter 162, the reference is to code enforcement boards, but there is always an opportunity, and most cities are actually moving to this system, to have a special magistrate in place who conducts an evidentiary hearing. And in that evidentiary hearing, the property owner is allowed to call witnesses, and did in this case, and to submit evidence, and the city did the same. At the conclusion of that code enforcement hearing, the special magistrate issued an order finding that the sign frame was an abandoned or discontinued sign. It was a non-conforming pole sign. In the City of Jacksonville Beach, the sign code calls now for monument signs. So this sign was due to be removed. She ordered it to be removed and gave the property owner 30 days to come into compliance. The property owner declined to do that, and she therefore issued the fine. Now, the ordinary structure under Chapter 162.11 Florida statutes is within 30 days, the property owner has the right to appeal that record that was presented before the code enforcement special magistrate. In this case, instead, towards the end of that 30 days...
Excuse me, counsel. This appeal is just a regular appeal, just like this appeal to this court. It's not like a special writ proceeding or anything like that?
No, this is an appeal from a writ of mandamus from the lower court.
I know. I mean, I'm talking about the code enforcement.
Yes, that was a regular appeal.
Okay.
And instead of appealing to the state circuit court, the property owner in this case elected to send a letter demanding that the city engage in a process under Florida Statute 70.51, which is the Florida Land Use and Environmental Dispute Resolution Act, which I will refer to as FLUDRA. Now, FLUDRA is a unique system, offers a landowner the opportunity to request a mediation process, and if that mediation process is not successful, they go to a hearing process. It is the city's position that the lower court erred when she issued the writ of mandamus, because the right to a FLUDRA proceeding under the facts of this case are not clear. FLUDRA addresses development orders, and basically the initiating right to initiate a claim under FLUDRA starts with a development order or an enforcement order.
And is your argument here that what the city did in this case was not an enforcement action?
It is our argument that what the city did in this case is not an enforcement action, as it is not clear that it's an enforcement action under FLUDRA, because unfortunately, FLUDRA does not define an enforcement action. And further, if you look at the structure of 70.51, the structure of the proceedings that the city would be required to go through do not apply to a code enforcement action.
Yeah, it doesn't, I think that's right, that it doesn't talk in terms of a specific type of enforcement action. It says any owner who believes that an enforcement action of a government entity burdens the property may apply for this proceeding. Given that it doesn't reference any specific type of an enforcement action, sort of a vanilla descriptor, why doesn't what the city did in this case fall within the definition of and give the appellees the right to 7051?
Because the 70.51, in effect, conflicts with the procedures in Chapter 162, which provide for an efficient remedy for code enforcement. Query, Your Honor, if this was an enforcement action for an overgrown lot.
Why can't they work together? You said that there was already some sort of a mediation type process that went on. This 7051, as I read it, provides for a mediation type process. So why can't 162 and 7051 be read together?
Because the 70.51 proceeding would delay the property owner from coming into compliance with the code, and it would delay the appeal process. And furthermore, it's simply not clear that this 70.51, the enforcement action in there, would apply to code enforcement proceedings. It's particularly not clear. And in this case, we're proceeding on an appeal from a writ of mandamus. Mandamus is only to be issued if there's a clear legal right, an indisputable duty on the part of the city to comply with that, and there's no other remedy available to the property owner. It's our position that the lower court erred because that didn't happen. The right's not clear. The statute itself does not define the critical term of enforcement action, enforcement order.
The statute does require, however, that it be liberally construed. So to the extent there's any ambiguity in enforcement action, why wouldn't we find in favor of the property owner's rights and then construe it liberally?
Because if there's any ambiguity at all, then it should not, mandamus does not lie. If there's ambiguity, Your Honor, then the city found it ambiguous as well. The mandamus only lies with a clear legal right, and that didn't happen here. And mandamus is a there are three elements. It's not just the clear legal right and the indisputable duty on the part of the city, but also there cannot be another remedy available to the property owner. And here, the property owner had the right to appeal the code enforcement action. And if you look at FLUDRA, there was...
I guess I have a little trouble with that because 705129 talks about its action being, or the provisions of this section are cumulative. So it seems to recognize in its very structure that it is it's a separate proceeding, it's a cumulative proceeding. That there will be other options, but this is cumulative. We want people to get together and try to work out these land use issues.
Right, and getting together and working out the issues, in this case, that's what this city and this property owner tried to do before the process of going through code enforcement. The challenge with the cumulative nature of this is that it delays the very goal of code enforcement, and that is to have the property owner come into compliance. Query if we had a dangerous situation here, or a nuisance that was a dangerous situation. FLUDRA would do nothing but expand the time frame for coming in to compliance under code enforcement. If you look at FLUDRA, it looks to me that it applies to situations like rezonings, where the public comes out in a hearing for a rezoning with a local government. the public has notice and an opportunity to be heard. Adjoining landowners to the area that's to be rezoned are given notice. Same thing is true with a conditional use.
Well, what
permit
type of
application.
enforcement action do you think this applies to?
It's not clear, Judge. It's not in the statute. The very thing that causes.
Is there any type of enforcement action you think it clearly applies to?
I would imagine a state agency action where the state agency issues an order directing a property owner to comply with some legal proceeding.
But you can't say that there's any action of local government, enforcement action of a local government to which this section clearly applies to.
I can't come up with any, Judge. I know what is remarkably missing from 70.51 is the word code. Code enforcement is a pretty common term, and the Florida legislature, when they passed 70.51, was certainly aware of Chapter 162, yet the legislature didn't mention Chapter 162. 70.51 does not preempt the provisions of Chapter 162, and the requirement of notifying adjoining property owners makes absolutely no sense in this case when the adjoining property owners don't get notice of code enforcement hearings. The requirement under FLUDRA that the city would have to go to yet another hearing creates confusion. And further, what happens if the city were required to go through the FLUDRA process? What happens with that record? In the end, the appeal would be to the state circuit court with the record that was in front of the special magistrate in the code enforcement hearing. And if there's no further questions, I'd like to reserve my time. Thank you.
May it please the court. Sid Ansbacher, Upchurch Bailey and Upchurch, St. Augustine, Florida, for the appellee. I've dealt with 7051 proceedings since we reviewed the statute for the bar, and I appreciate the background that the counsel for the appellant has given you, but I think that the questions that you all were asking might best be answered not with the background of the propriety or not of the action of the city, but as you've indicated, the statute itself. Section 2A defines development orders. That's the side that Ms. Erdely refers to, as essentially tracking 163's definition of development orders and referring to the grant, the denial, the grant with conditions of a development permit. Also in 2B, defined substantially as it is in 163. And in that subsection, it includes lots of what I would call tabletop approvals that have nothing to do with third-party notice, such as building permits, site plans, and the like. And the statute refers to, among other chapters, 125, 166, the local government statutes, home rule authority. Enforcement action, as you've indicated, is not limited in that regard. Enforcement action, as defined by David Powell, Bob Rhodes, and Dan Stengel in their seminal article in the FSU Law Review, and they were the principal drafters of the statute, is supposed to be interpreted broadly. They basically made the very sound position that enforcement can be in any number of guises. And I think that Ms. Erdely's concerns about the limitation of enforcement vis-a-vis development can be allayed to some degree if you actually look at the definition of owner, which is in 2D. There are two different standing rights for a development order affecting an owner. The owner can be the owner of a legal or equitable interest, And for an enforcement action, the second prong, it can only be someone with a legal interest. The definition of property includes both property per se and any improvements or appurtenances on that property. And Judge Osterhaus, what you indicated regarding the initiation of this action is key. Subsection 3 says that any owner who believes there's no good faith, there's no reasonablement requirement there. It is simply a belief. You may imply that or infer that there is a good faith obligation, but it is predicated upon the owner's belief that an action of government, whether it be a development order or in the alternative, an enforcement action, is unreasonable or unfairly burdens that owner's property, may initiate the 7051 proceeding within 30 days of receipt of notice of either.
If this doesn't apply to the code enforcement actions of local government, what kind of enforcement actions of local government would it apply to? Or what's the universe, I'm asking?
The universe is, as Ms. Erdely pointed out, what if there is a nuisance? They could bring a public nuisance action today in circuit court. That would be a common law or home rule authority that they would have. They also have the authority in 162 to either have a code enforcement authority by administrative action, or they can initiate in county court. So our view is that enforcement action in the context of local government falls into either code enforcement or common law enforcement. In other words, code enforcement is a subset, if you will, of enforcement action. It is not something that is ambiguous. And as Judge Ray pointed out, subsection 29 of this statute provides not only that it is supposed to be interpreted broadly to affect the goals of trying to facilitate resolution of such disputes, the local government shall apply all of its resources to effect the goals of the statute.
What about the argument that the notice provisions really just don't make sense in the context of code enforcement orders?
Well, I go back to what I said earlier. If you look at it in the context of the development permit side of 2B, building permits are commonly issued in over a tabletop at a building department. Site plans, commonly, various of the listed development permits under subsection 2B are not issued in a public forum, let alone with third-party due process rights in a Snyder-type setting. What subsection 5 provides is that the government, upon receipt of the request, after it must initiate the process at the governmental level by sending to a jointly approved special magistrate the application for the 7051. Under 5, it says two things. One, you provide notice to all neighboring property owners who may or may not have appeared below. And 2, in what I will freely acknowledge is a very stilted subsection, and as someone who's been in this process, it's difficult to even apply. You then give notice to people who appeared below if there was a third-party hearing and who expressly requested notice in the event that, for example, my client were to initiate a 7051 proceeding. So in actuality, what you end up with is often notice that goes only to neighbors, or if you have a special magistrate who cares about effecting the process, they'll just give notice to everyone who appeared if there was a public hearing. I'm sorry, go ahead.
Obviously, the issue here is, what constitutes an enforcement action.
Yes, Your Honor.
And you've kind of tried to say that it includes code enforcement. What about, what I was thinking about was, what about a criminal action that affects, that a person, an owner believes unreasonably or unfairly burdens the use of the owner's real property. I'm thinking about maybe I decide to set up a little stand in my front yard and sell beer from it. Beverage agent, maybe police officer comes up and says, hey, you can't do that, writes me a notice to appear, says that I'm violating the law against selling alcohol without a license. I say, wait a second, I think that unreasonably or unfairly burdens the use of my real property. Can I stop the criminal action or somehow delay or stay the criminal action while I seek my remedies under 7051?
I would contend that it applies to administrative actions only.
But why? Why is enforcement action limited to what you say? You want it broadly construed, but to anything that, unreasonably or unfairly burdens the use of the property. You said that as long as the owner believes it, then this section applies. So why not there?
I would say that if it applies anywhere at all, unquestionably the heart of enforcement action is this, the code enforcement, and that there is no dispute that code enforcement would constitute an enforcement action of local government. If you start getting out to the perimeter of a criminal action, I cannot speak to that. I can say that I think they can reasonably, fairly, and without going beyond what the Hawley case says, which is if there is plain language, if you look at Aberdeen, if you look at the Rinker decision, plain language is to be interpreted in a plain and unambiguous manner. And again, one other thing that I think is essential on the mandamus aspect of this is what Judge Cole focused on is the terms must and shall. But again, I think it's important to understand how this whole process under the statute was bypassed by the unilateral refusal by the city to participate. Subsection 8 and subsection 19 work together to effect within the context of the statute what it is that Ms. Erdely seems to be concerned about. Subsection 8 provides, if I as a special magistrate determine that the petition for 7051 action does not meet the criteria of the statute, I can as special magistrate issue essentially an order to show cause that if it is not resolved can result in a dismissal with prejudice. And 19 is essentially where the special magistrate has the authority in determining whether there is an unreasonable or an unfairly burdening act. And at that point, if the concerns that the city seems to have as to whether the action meets the criteria are met or not, that's what the statute provides. They can make their arguments both before in the Section 8 proceeding and again at the end in their allegations in subsections 18 and 19. And as far as unreasonable delay, I want to point out the statute specifically provides this is supposed to be an expedited process. It allows for up to 165 days. In actuality, in a case of this magnitude, it would probably take substantially less, probably half as much. I want to point out we filed for our request, I believe, August of 2004. If the city had proceeded and made the same arguments within the context of a 7051 proceeding, we would have been done in all likelihood in 2004. And to that end, I want to emphasize what Judge Cole noted, and that is that the city in presentation today has said, what about the alternative of appeal? And again, I believe Judge Osterhaus was talking about how this is a cumulative process. The whole point of this is to try to have what, and pardon me for quoting someone I didn't quote in our brief, but Carlos Alvarez does a lot of these. And Carlos actually, Mr. Alvarez refers to these sorts of processes as a chance for both sides to take a deep breath and try to work things out. And while I recognize that Ms. Erdely believes on behalf of the city that the process delays unreasonably an appellate process, but first, that's for the legislature to decide and has decided, and according to Peninsular Properties, properly decided. And also, if you do what the city has done here and say, I gotcha, you should not have done this, you should not have entered into this process, then what you can do is bypass the entire process unilaterally and leave people in the position of the appellee with no remedy in a situation where the statute clearly provides that this is supposed to be cumulative and for the purpose of avoiding.
Counsel, what it says about the cumulative provision is it doesn't supplant other methods agreed to by the parties and lawfully available for arbitration, mediation, or other forms of alternative dispute resolution. It doesn't say this is cumulative to any other kind of enforcement action available in the entire body of law. It seems to me that this is just simply cumulative to other types of alternative dispute resolution that the parties may agree to.
The action is legislatively created in order, according to subsection 10A, to abate judicial review long enough to allow the parties to try to resolve their differences.
Let me ask you this. Let's say this were just a development order and it wasn't an issue of whether this is an enforcement action. I feel like I am unfairly or unreasonably burdened by a development order. What are my remedies other than this?
Other than this, 163.32.15 for a comprehensive plan challenge. Of course, you have common law cert. You have, in addition to that, the potential, of course, for facial and as-applied challenges, for constitutional challenge, or for any other remedy that you might have.
So what it seems to me then that if I am adversely affected, this is my primary remedy unless I want to do an extraordinary writ or a constitutional challenge. Whereas it seems to me what appellant is saying is there is a remedy that's provided in law here. It was actually granted. There was a code enforcement hearing, an evidentiary hearing at which your client was allowed to present evidence, and there's an appeal to the circuit court. So isn't that different than somebody who is adversely affected by a development order to where this is really their primary remedy to challenge it?
I would challenge that this is supposed to be an alternative dispute resolution to the appeal, no matter in what regard from the administrative decision, no matter whether it is a development order or enforcement action. And if not, as Judge Ray was pointing out, there are 41 references to enforcement action in this statute. They've got to count for something.
Thank you, counsel.
Thank you.
FLUDRA is an effective procedure for development order cases. My opponent mentioned Carlos Alvarez. I recall a case, watching a case where a big box store was going into a community. Members of the public had spoken out against it. The application was denied, and then this process ensued. Because the public had an opportunity to be heard in that first process, it would be logical that if there was an alternative dispute resolution process in FLUDRA, that the very same people would be allowed to participate in the alternative dispute resolution process. And that's the spirit of FLUDRA. Interestingly, when asked about a question about enforcement orders and whether FLUDRA applied to your situation with law enforcement, the example I would come up with law enforcement is query if Brothers 5 was growing marijuana on their land and law enforcement engaged. That would be an enforcement action, and broadly construed, it referenced the land and it might fall within FLUDRA per my opponent's argument and per the lower court's order. Yet my opponent's response to that was basically the spirit of FLUDRA doesn't provide for that to be an enforcement action.
So how do you think, if we were to write an opinion in this case, how would we define enforcement action?
I think that is incumbent upon the legislature to do.
Well, we have to apply it to the facts before us. So in doing so, we would have to define it by the absence, I mean, if you prevail, the absence of code enforcement proceedings. And so, I mean, help us craft what that would look like.
Well, for starters, Florida Statute 162.02 has conflicting components to FLUDRA. It provides that it was the intent of the legislature in that statute to provide an equitable, expeditious, effective, inexpensive method of enforcing any code and ordinances enforced in municipalities. That is in conflict with FLUDRA, and the legislature knew that Chapter 162 was in place when FLUDRA was written. Therefore, one would presume that the legislature did not intend for code enforcement actions to be an enforcement action in the FLUDRA matter. Moreover, the provisions of notifying adjoining landowners simply do not apply. I can't imagine the phone calls that would come into my city if we started calling the adjoining landowners on code enforcement actions because some code enforcement order recipient decided that they wanted to participate in FLUDRA. And FLUDRA is supposed to be an inexpensive method. Well, it's not inexpensive. The city has to pay for the special magistrate. The city has to pay for the attorneys in that proceeding. We actually have used FLUDRA in our city when appropriately applied, and it is an expensive remedy. There are no other questions. I thank you.
Thank you. Thank you, counsel. Appreciate it.